of Professor Leon Friedman. Many of you know, and maybe some of you don't know, that Professor Friedman graduated from Hofstra Law and I'm sorry, I always call Hofstra Law when other people call Harvard. I call Harvard Hofstra Law, but our professor graduated from Harvard Law and University. After his graduation from Harvard, he took a position at K. Schuler, and he left when amazing, because of his many talents, a play that he had written, The Trial of Lee Harvey Oswald, was produced on Broadway and later made into a TV movie. The professor was general counsel at a publishing firm. He was the assistant director of a committee on courtroom conduct for the Association of the City of New York, where he co-authored Disorder in the Court, which is a leading work on that subject. Thereafter, he was the director for public justice at the American Civil Liberties Union during the Watergate era. At the ACLU, he litigated numerous cases dealing with national security, misuse of government power, the Vietnam War, and of course, with relating to drafting and the First Amendment, and continues to this day to write amicus briefs on important Supreme Court cases, not only for the ACLU, for Penn American Center, for the Association of the Bar of the City of New York, and many, many other public interest groups. The professor has testified before Congress on numerous occasions, and Professor Friedman authored more than 100 law journal and newspaper columns for the New York Times, The Nation, and many, many other publications. His book, Justices of the United States Supreme Court, from 1789 to 1969, won the annual Scribes Award for the best book on a legal subject. He has published and written numerous books, and he is a leading copyright lawyer. And he's represented some incredibly interesting and talented people in the entertainment world, such as Kathleen Turner, James Brown, Susan Sontag, to mention just a few. He also represented Gene Harris in a First Amendment case dealing with the Son of Sam law. And he also represented Reuben Hurricane Carter, who for which he obtained a writ of habeas corpus, no easy task. And Hurricane was released after a 19-year imprisonment. And actually, there was a film featuring Denzel Washington about, quote, the hurricane. He also has lectured many, many times for the Federal Judicial Center, and he is highly sought after as a lecturer, as you can imagine. I know many federal judges that have had the pleasure of hearing him speak, and he gets rave reviews. It is my privilege and pleasure to provide this introduction. Professor Friedman is a fabulous colleague, a wonderful person, and a distinguished professor. And now it is my pleasure to turn this program over to two distinguished professors, our academic dean, Julian, and of course, our constitutional scholar, distinguished Professor Leon Friedman.
Okay, thank you so much, Deane. Thank you so much, Deane, for that introduction. I just want to sort of begin by just laying out, well, first thanking Professor Friedman for agreeing to sort of serve as our Constitution Day speaker, and to thank everyone, all of you out there, for joining us on this Friday. I know it's a little weird with Zoom, but I do appreciate everyone signing on, and we promise to keep this fun, interesting, but also not too long. So here's just to give you a preview of how Professor Friedman and I plan to proceed. We're going to sort of kind of have a conversation. So there are so many topics Professor Friedman could give long lectures on, but I thought maybe to get the best bang for our buck, we would take him through a variety of different topics that he has different great insights and expertise on, and to really think about also to take advantage of the fact that, unlike many of us, Professor Friedman has a really great long view on the Supreme Court, even though some of the things we think that Supreme Court are new and the latest thing has never happened before. Sometimes Professor Friedman will remind us, actually, no, back in 1865, they did exactly this, or, he has a lot of great insight perspective on this. So we'll have a conversation on three topics: of future of the Supreme Court in the history of reforming the Supreme Court, the role of the court in U.S. society, and then we'll talk about some of the big hot button issues that are before the court today, but also getting some historical perspective on this as well, from both from his own sort of time beginning and ending with observing the court over the last 50 years, but also from his studies of the court from prior to that. So it's a really great opportunity for everyone. I really appreciate Professor Friedman for joining us today. So, and just as a quick reminder, in case you didn't hear me, you should be able to put your questions in the chat, I think, and as we go along. So don't wait until the end. We will leave time for the end for questions, but if you have questions as we go along in the conversations, let's just go ahead and put them in, and I'll try to bring them up as we go through the different topics. But you can also save questions for the end when I'll open it up. So Leon, let's go ahead and get going. So let's begin by talking about the hot topic for today. Right now, the Supreme Court, President Biden has appointed a commission to consider reforms to the Supreme Court, including most controversially, adding justices, increasing the number of justices that sit on the Supreme Court. So I guess maybe you could share with both your historical perspective on, how often has serious reform of this kind been contemplated for the Supreme Court? Beyond the 1930s incident, can you give us some sense of other eras, or is this really unique, and what we're thinking about today is really unprecedented? And then we can talk about the merits of any reforms out there. But why don't you go ahead and give us some of your thoughts on the history of this and where we are from a historical perspective, maybe.
Well, let me just start with the numbers. The Supreme Court started out with 6 justices. Why 6? And the reason was that Supreme Court justices were also trial judges. Back in 1789, there were 3 districts. There was northern, southern, middle. And 2 justices would act as the trial judges, federal trial judges, in each of those districts. So they always performed two jobs. I mean, they would have to travel over the entire country. I mean, if you were the Southern Circuit judge, I mean, why is that word circuit? Ninth Circuit Court of Appeals. Because judges used to ride the circuit. They used to go from one town to another in order to hear whatever cases there were. So we started out with 6 Supreme Court justices, and it was directly related to the number of circuits that we had, 2 in each of them. Now, in Jefferson's time, as we expanded out west, we added another justice in 1807. And then in Andrew Jackson's time, there were 2 more justices. So we had 9 going into the Civil War. And the number of justices at the Supreme Court was always related to the number of circuit judges, that would, as I say, travel around the country. I mean, justices would travel around the country and act as trial judges right up till 1890. I mean, that's the way the system worked. They were not just appeal court judges. And every time there was an addition to the court, it had to do with additional circuits so that in Andrew Jackson's time, as states came in the Midwest, you had to determine a new circuit for that justice to travel to, and therefore we needed two. Now the Civil War had its own problems. As you know, one of the justices sitting on the Supreme Court left to join the Confederacy, John Campbell, and by this time California had become part of the country, so we added a 10th justice for 2 years, from 63 to 65. There were 10 justices on the court, again related to the circuits, related to the different places that they had to travel. Then, of course, when Lincoln died, and Andrew Johnson being president, the first thing Congress did was limit the number of justices that he could appoint. So it was dropped down from 10 to 7. There was still some justices sitting there, but the court in 1866, or the Congress in 1866, reduced the number of justices from 10 to 7 because they didn't want Johnson to appoint anyone. Then, of course, when Grant was elected president in 1868, we went back to 9. But remember, they were always related. There's nothing magic about 6, 7, or 9. It had to do with serving as a trial judge, because that role was very important. After 1890, we set up 9 separate circuits, and the justices no longer had to actually, they do supervise. I mean, we now have 14 circuits. No, 13, I'm sorry, 13 circuits. We have the 9, and since 1890, 4 circuits were added. The DC Circuit, the 10th Circuit, the Federal Circuit, and the 11th Circuit. Now, in theory, we should add 4 justices to the court, and right now, Chief Justice Roberts is the circuit justice for, I think, 3 or 4 separate circuits. It's a lot of work for him to do. So why don't we add, to be historically accurate, or to follow the history, we could easily justify adding a few justices to the Supreme Court and assigning each of them to supervise the circuit, to do much more than they do now. I mean, the problem about adding justices to the Supreme Court, if the only purpose is to overrule an earlier case, then it really looks very political. But if you can imagine some good reason for doing it, and my good reason would be we want each justice to cover each of the circuits and to have more of a role in running, organizing, the appeal court, the appeal process. But that's since 1868, when the 9 were picked, except for the FDR. I mean, FDR's court packing had a bad reason for adding it. The bad reason was justices grow old, and we have to add a justice to the Supreme Court for everyone over 70. Well, I'm 88, I'm doing perfectly, it seems to me I could sit on the Supreme Court. If you're over 70, there's no reason for it. But at any rate, that's the problem. Is there some other justification for adding justices to the court other than we don't like what the last court did? And that makes it much more difficult.
So maybe that is going to transition directly to today then. So if there have been a lot of groups now calling for adding justices to the Supreme Court, and President Biden has a commission that's studying this. I'd have to say it sounds like from a lot of the groups that are pushing it, the argument would be on the bad side of the spectrum. It's not structural or adding, need to have the number of justices, but maybe it would be because the way that Justice Kavanaugh and Justice Barrett were appointed, given the lack of a hearing for Justice now Attorney General Garland. But those sound to me like political reasons. And would you accept those as justifiable reasons to expand the court?
Well, I think you have to have a structural reason, to expand the court. Is 9 really the right number in terms of what the Supreme Court does? They used to take, not too long ago, they would take 150 cases a year. I mean, in the 1990s, there were 150 cases. Now we're down to 70. I mean, they've literally been cut in half. Now, why is that? And one reason is because the justices thought that this was, there was a very big burden on them. You have to figure out some reason relating to the work that they do to add justices. So it seems to me if you come forward and say, let's add 4 more, make each of them in charge of a different circuit, and the work of the court will then spread out, and we'll be able to hear more cases. Hearing 70 cases a year is, I hate to put it this way, a little lazy when you get right down to it. I mean, so the justification that can be offered, I think, should focus on the work of the court. How can we make the court work better? And will adding justices do that? And I think there's a plausible argument for saying yes.
Okay, I mean, I think that's interesting. I mean, although my understanding is that the reduction in the number of cases that they hear is not so much the workload, although it's maybe part of it, but it's also just they choose they don't want to hear that many cases, I guess. But it's an interesting problem. That leads me to sort of a different question. I know there are a couple other ideas that the commission might be considering. One kind of radical one was to get rid of cert. So, and then you would really need more justices. So in other words, to try to limit the discretionary jurisdiction. Right now they have discretionary jurisdiction, but maybe create cases where they have to hear them, or where they don't have complete control over their docket. That might be an interesting way to. And then in that sense, you would say, yeah, we do need more justices. And then maybe we'll have panels within the Supreme Court to hear certain cases. Is that something that you've ever thought would be an attractive reform? Or do you like the way it works with all 9 sitting there? They can have completely control of their docket.
No, I do not think that you should eliminate certiorari. I mean, there was a time, by the way, when they did have to take, again, in the late part of the 19th century, they were taking all these cases. There were a lot more than 150 because they didn't have discretion. But I think discretion is a good idea. There are a lot of cases that don't merit consideration by the highest court of the land. So, but I think there is a concern about the reduction. I mean, if you talk to a justice, he says, "Oh boy, June and July is horrible. We have to write so many cases." They really think there's quite a big burden on them. And I think that's one of the reasons why, I mean, it's not a lot. Each justice, if there are 70 cases and there are 9 justices, each of them, have to write 7 or 8 opinions. Doesn't seem all that hard, but they work very hard at it. And they each have 4 clerks, and they will work very hard at this.
I mean, I'm a professor, so maybe we're both professors and maybe not in a position to cast aspersions on the Supreme Court justices' work habits, but less than 9 cases a year compared to circuit courts is remarkably small, right? Plus they have 4 clerks. That's a very. I guess what I'm worried about, we add 3-4 justices and they take 70 cases still, right? And then they have even less work. Doesn't that? I mean, how do we avoid that problem, right?
Well, I assume. Again, you have to believe that they're going to act in good faith. Presumably, if there are 4 more justices, they will go back to something like 150 cases per year, and they have to be told, we expect you to work harder from now on. If we're going to change the system, and I think they would act in good faith on something like that.
Let me push you on one other reform that's out there, which is probably more popular than one I just suggested, which is, I think I already know what you think about this, which is term limits. So term limits, not a retirement age, but a term limit. In other words, you get 1 unrenewable term, and then that way every president, you can stagger it to every president, say gets 2 appointments, and then we don't have this sort of weird sort of thing where we're waiting for justices. We're really worried about their health, or we're trying to pick really young justices. Do you have any views on this idea?
Well, you know, the European judges are term judges. They're for a period of time. Even the judges that sit on whatever the European constitutional courts are. I think it's 10 years, something like that.
It could be 15, 10, yeah.
10 or 15, something like that. So it is possible to have a system for higher court judges to do, but somehow, again, tradition, you know, somehow justices get better as they grow older. You think of Oliver Wendell Holmes, you know, in his 90s, really doing this wonderful work. And, you know, maybe if we give them more time, they'll end up doing a better job. It doesn't grab me, I must say. I don't think that's a reasonable solution. Again, you sort of get attached to the way the system has worked. And as a general matter, I think it has worked well.
Okay, well, that's a transition to maybe my second category of questions for you then. And your perspective on this, I think, is really great and valuable, especially for our students, all of whom are like, you know, kind of children of the 2000s, right? So a couple thoughts on this. One, I mean, from your perspective, does the court seem more political, or is it viewed more politically today? And a couple ways this has happened. One is through the confirmation process, which has become really contentious, even more contentious than it was in the past. Or are we just a prisoner of the moment, and it's always been contentious and always been political and politicized? Because this goes with the idea of reform. I think if you believe the court is being seen as too political, or it's becoming too political, maybe we need to reform it so that it's you know, it's less powerful, or has something that makes it less political. Or do you think that to some degree we're just a prisoner of our moment, and it's always been highly politicized, both confirmation hearings and their decisions? What do you think about that, as compared to, say, when you were first coming up in the 60s and 70s?
Well, listen, from 1789 to 1953, why do I pick those dates? The court was always a restraining body against general reforms. They were always negative. They were always, I mean, you go to Dred Scott, the Dred Scott decision, a horrible decision. And then the Reconstruction, then Congress comes along and passes all kinds of Reconstruction laws. The Supreme Court strikes them down. Then Congress starts regulating businesses. The Supreme Court strikes it down. And so the Supreme, from the beginning, you know, there was a little period in 1900 when they were doing some good things. But if you look at the history of the Supreme Court and what it did, there was always holding back reform. They were always finding reasons why reform or, you know, progress should be held back. And it was only in the Warren Court, 1953, Brown v. Board of Education. I mean, when Brown v. was argued, John W. Davis, who argued the case for South Carolina, says, you know, the Supreme Court 10 times, you know, had upheld separate but equal. You know, and they had 10 times the issue of separate but equal came before the court, and they accepted it. And it was only when Warren came along, there's this very famous story that he had lunch with Stanley Reed. Reed was still going to dissent, and persuaded him not to. And then, and I must confess, I was alive in 1953 and 54. And all of a sudden, it was a big change, because up until then, we were always fighting. We progressive people, progressive lawyers, civil liberties lawyers, were always fighting the Supreme Court because they always were a restraining influence on progress reform in the United States. I mean, that's the general rule. Suddenly, the court, you know, we have Brown v. Board of Education, we have Roe v. Wade, and suddenly you now look to the court, you know, to recognize the changes in our society and to assist in that way. And that's, as time goes on, that's comparatively new to look at the court as a positive a feature of change. And so how do you make that happen? How do you continue? How do you persuade the court to continue its new role?
I guess the flip side of that would be that the court's move in the more reform or progressive direction has arguably also made it less popular, or maybe it hasn't. But there has been certainly political backlash, which explains maybe why we have, as a lot of critiques of the court and the belief that it overreached, right? So maybe that progressive movement on the court they should have stuck with the legislatures rather than to put so much effort in using the court as an engine for reform.
Well, these were new issues. I mean, discrimination. Segregation has been an issue in the country for 100 years, for almost 100 years when that came up. But all of this takes time as society changes. As I say, we used to have to fight the court who didn't recognize the change. Now we say, wait a minute, why don't we use the court as an ally in helping us change? I mean, to have the Supreme Court recognize gay people and trans people as covered by the sex discrimination laws, that was a big change, but they did recognize what has happened in society. It's rare for them to be the moving force, although they have done that a couple of times.
But also, then does that make them seem more political, which is going back to my concern, at least that they're seen less as justices applying the law and more as political figures. That has manifested itself in these really ugly confirmation battles that we have.
Well, but now, I mean, the reason for that is that a lot of the issues that now become legal issues. I mean, a lot of these things were not considered legal issues, but now we look at them. We have passed civil rights laws. And we look at the kind of discrimination that exists in this country as something that the law can do something about. Not only, gender discrimination, not only racial discrimination, but, we do pass laws dealing with those issues, and necessarily the courts have to then examine them. So, I mean, like it or not, the court has jumped in largely because society has now recognized that there is a legal basis for this.
So actually, this is a nice transition maybe to some of the particular issues the court has been battling with, really for the last 50, 60 years. Let's take 1953 as our starting point, I guess. So let's just, for instance, and this one is where the court probably is the most controversially got out maybe in front of society, or maybe it didn't. So Roe v. Wade comes down in 1973. And there were statutes, but it wasn't a statutory case. It famously, found the right to have an abortion in the Due Process Clause of the 14th Amendment, and grounded it in constitutional values, and really set off this really massive political debate in our society about abortion, and has really been front and center for the court. So my first question for you on abortion rights is, when Roe v. Wade came down in 1933, was it as controversial then, and did you expect it to be as controversial then as it continues to be now?
Absolutely. Absolutely. I mean, like it or not, there is a very firm religious opposition to abortion, and that doesn't disappear. That's still with us. And so then, as the rights of women, started to rise, it suddenly, there was this, which is what abortion is all about, the right of a woman to decide how, what to do with her own body. but we do have this very strong religious objection to that. And, that has always been there and it still is there today. You say these are political. They're not really political. They've become political because people then, jump in and want to pass laws, relating to this particular issue. As we now know, Mississippi, Texas are trying to stop that. But there is a very substantial minority, I have to put it that way, that feels very strongly about that issue, and they translate that into legal objections. I mean, that's what's
I guess what I mean, but just to clarify what I mean by political is that overturning Roe v. Wade became a platform in the Republican Party, I think maybe at least as early as 1980, maybe even earlier, and appointing justices that would interpret the Constitution according to its original intent. But also, frankly, some candidates say, "I'm running, elect me. I'll vote someone to overturn Roe v. Wade." That makes it a political issue, just whether you agree with them or not. And I think, given that Roe was not grounded in actions by Congress or state legislatures, but in fact overruled their decisions of some, like Texas, isn't that an example maybe where the court did get out a little in front of society and then faced a backlash, a political backlash, and made themselves more vulnerable to political attacks?
Well, there were we all know this. I mean, in the early 1970s, various states, New York, a lot of the liberal states, abortion used to be a crime everywhere. And it's sort of interesting because was there anti-abortion laws in the 1789? Absolutely not. You can't go back to 1789 and say, well, abortion was illegal. Not true. I mean, there were women who were there was a basis for stopping pregnancies. And then in the 19th century, it became a medical issue. You can only do it to a doctor. There were various laws saying that you couldn't engage in this kind of process without medical assistance. And then the medical profession started to object. And you always had this, religious feeling about that. So, I think the rise in abortion had to do with the rise in women's rights. Among other things, we don't want to be discriminated in employment, and we want to have a say in what our own body does. And so it was that kind of an issue that persuaded courts around the country, legislators. Before Roe v. Wade, I don't know, there were 10 states that had overruled their anti-abortion laws by that time. And, the Supreme Court responded, I think, to this, you want to call it a political, okay, let's call it a political movement, to recognize the rights of women to decide, how their own bodies should be dealt with.
Yeah, fair enough. And, so let me actually give you a chance to talk about a little about these upcoming cases then, because, and maybe frame it this way. So how, there's the Mississippi law, there's that Texas law that's currently has a very complicated way it's organized that makes it really hard to challenge. But, these laws, I guess, do you have a view on, I think I know what your view is on the merits, but maybe a prediction on maybe how the court will proceed and how it would affect the court if they do either uphold some of these laws or go even as far as to overturn Roe v. Wade?
Well, it's bite by bite. You make everything more difficult. We have the Casey decision. You have to wait 24 hours, before you can have.
If a state wants to. If a state requires. Right. If the state requires 24 hours, right? But a state doesn't have to require 24 hours.
Well, but the only thing they struck down in Casey was the spouse approval. It's very interesting, by the way, because I was at the ACLU at the time. The ACLU pushed that case so it would be decided in 1992. They could have waited. Pennsylvania Supreme Court decision came down in December. You have 3 months to file a cert petition, and that would have put the case over till 1993. But the ACLU said, no, we want the Casey decision to be decided before this presidential election. And they, it turns out, and they thought, the reason for it was, they thought the Supreme Court, we had all of these Bush appointments, 3 Bush appointments, and everyone thought they were going to go along with the rest of the Republican Party, but they didn't, and they wrote the separate opinion in Casey, of course.
You thought they would ACLU thought it was a better strategy to have them strike it down so there would be a good election issue?
That's correct. Exactly right. And everyone was surprised. I remember, guess what they did? They affirmed the Pennsylvania Supreme Court. But to that extent, and by the way, there's a lot of that attitude right now. Let the Supreme Court decide this, let them do something really bad with this Mississippi case, and that'll be reflected in the 2022 congressional election. There really is that attitude out there. There is a 70% approval rate for Roe v. Wade. Okay. The problem is it's a very strong base against abortion, whether it's primarily religious based, but there is that base, and like it or not, the Republicans believe that the same base that is against abortion, for whatever reason, also supports a lot of their other positions, and that's made it that's why it's a core political issue for the Republican Party.
I guess I think that it's a good issue for both sides. Both sides think they win.
That's right.
But maybe the country loses as we have this fight. I'm a little concerned about this, because I do think it will. It's going to be quite a struggle in this issue. Let me shift to a couple other controversial issues that are coming up. Here's one I think is we talked about this maybe before the talk. The changes in the court's view on how to interpret voting rights laws. Now, this is mostly out of the Voting Rights Act 1965. Just this past summer, the court in Brnovich adopted interpretation that was, that was pretty narrow, at least in terms of, the scope of what restrictions could be permitted under the Voting Rights Act. This is some area where there probably has been a change, but isn't the change here reflective of the change in the society and the country, you think? Or do you think the jurisprudence or the attitude of the court is what's driving this?
Well, listen, there was a time, a lot of you don't believe it, when the only time you could vote was on election day. There was no prior slipping it in.
Early voting.
No early voting, no boxes to put you only stood in line on election day at the voting. And this was on a Tuesday in November where you had to work. And this really was a burden on people who had a regular job, and at 5 o'clock they had to go and wait in this long line. So there was an effort to sort of, open up the process for the workers, for the working class, for, unnecessarily for minorities. You look at the Georgia law, and you compare it to what used to be. You only stay in line on election day. And all of these are liberal, if you want to call it that. And the way the Supreme Court decided it's not that much of a burden, it's only 1%. They use these numbers, it only affects 1% of the minorities, only affects majority 0.05%, but 0.5%, but only affects minorities. So you have to be a little more realistic. How does it, as we all know, we vote less than any other country in the world. England, France get 80% voting. You know, we're lucky if we pass 50% in any election. And, you know, the reason for it, again, is people at the bottom who find it more difficult to do this, who are very cynical about the way the whole system operates. And, you know, to get them, to encourage them to join the system is why we had a lot of these reforms. But, you know, the Supreme Court in the case, Bogdanovich or whatever it is.
Bogdanovich, yeah.
You said, look, it's only a minor, when you compare it to what used to be, this is only a minor difference. But who does it affect? It does affect the people at the bottom.
Let me just take we're running a little bit long here. So let me just take, well, one more topic that is close to my heart, and I know that you were interested in, which is not something the Supreme Court has dealt with very recently, but I think it's something that was really a big, well, maybe not the biggest part, but something you're really interested in the early part of your career, which is the Vietnam War's legality and the U.S. government's use of war powers. Of course, you know, in this case, would you say the court has been pretty laid back and continuing its policy of not interfering? And it seems like there's less prospect of the court ever drawing a line. But I was curious whether you think there has been any real dramatic shift in the court's role in determining war powers for the United States.
Well, let me tell you, when the Vietnam War came out and all this opposition came up, I was at the ACLU. You know, what can we do to stop it? And we had the idea of having the draft declared unconstitutional. Why is the federal draft unconstitutional? We never had a draft in this country except for 2 years in World War I. So conscription, and there was discussion about this in 1789. There were a lot of people who didn't want to have any federal army. And the concern was if there was a federal army, they would act like, you know, like the English royal family. So, you know, we should not have no. So we had some Columbia history students and I put together a 150-page brief to show how conscription is unconstitutional. Congress did not want the federal government to have, that's why they have all these militia provisions in the Constitution, because the militia could be the answer if the federal government became tyrannical. Well, if the federal government could draft everybody, then, you know, it doesn't mean anything.
Just a question in the chat was about, what about the Civil War? I think you said something about that. So.
Well, there was in the draft during the Civil War, you could buy a substitute. You didn't have to go in. You just paid $100. Yeah, you could. Not in World War I, I can assure you. So I don't know if it was a real draft if you could buy a substitute. But at any rate, we fought the draft. You know, we had this brief, went around 15 cases. Judges are very. I talked to Scalia about this. We talked about this. I said, suppose I prove to you that the federal, absolutely, you want to go back to history, you want to know what the original founders thought, they didn't want the federal government to have the power to draft. What do you think about that? He said, look, I'm an originalist, I'm not a nut. Yeah, I'm not crazy in doing this. But in terms of the war power, I mean, again, Congress never passed a war powers resolution. They never, when we were in Vietnam, there was the Gulf of Tonkin resolution, which was very broad, and that got repealed. So there was no statutory basis for carrying on the Vietnam War. And we actually had a federal judge, and then when the war was over, we went into Cambodia. Even after we left Vietnam, we started bombing Cambodia. And Congress did not approve that. And we had a federal judge in New York who ordered the bombing stopped. And guess who overruled him?
Yeah.
The United States Supreme Court.
But do you think the court today, which has been, now granted, all the war on terrorism, 9/11, Iraq, were all authorized by statute. So those, you know, would not raise the same legal problems. But, you know, President Biden launched attacks recently that were not authorized by any statute, you know. No. So they continues to linger these issues.
Well, Under the War Powers Act, the president can do a war all by himself for 90 days. You know, with all our weapons, you know, how long does a war last these days? But I'm telling you, Donald Trump would have had the legal authority to drop bombs on China, North Korea, under the War Powers Act. I mean, that's the way the law reads. And that was considered a big, you know, restriction on presidential war power. But we had to give him the right to, you know, to act all by himself, herself, for those first 90 days. I mean, it's sort of.
I think you're not happy with that, the way that part of the provision came out, a little too generous.
I mean, the fact of the matter is that, you know, we were fighting against the Vietnam War, and the senators, I remember Javits was talking to us about what should I put into this law in order to do it. And we argued about the 90-day rule, but he said, no, we have to have something like that. As long as Congress had the power to stop him. I mean, Congress could stop him immediately. And they did, by the way. Congress passed a provision, no more money shall be paid for the war in Cambodia. You know, so they do have that power.
Fair enough. All right. Well, I know we've kind of we started a little bit late and we're running a little long, but I do want to get to some questions from the audience. First, let me just give you directly, there's a question that Professor Hofstra put in the chat, which was, do you think the late Justice Ginsburg's legacy will be tarnished by the fact that she did not retire under the Obama administration, that she may have been capable for serving on the Supreme Court until her death, but doing so set the stage for the court to reverse much of what she had accomplished? And similar questions are being raised now about Justice Breyer, who's not planning to retire, even though there's a risk of a Republican Senate and making it hard for him to be replaced.
Well, talk about making the Supreme Court into a political organization. I object to that. I think Ruth Ginsburg had every right. She says, I'm going to sit on the court as long as I can and do the same kind of work that I've always tried to do. I don't know whether there will be a successor that will do that. I mean, you know, could you predict that this cancer would come back? She didn't assume that. And Breyer is still functioning. I mean, he's been up there for 27 years.
You don't think they have an obligation to the, aside from the personal issues, but to see how the jurisprudence be affected by the fact that they might be replaced by someone with very different judicial views?
No, I don't like that idea at all. I think both of them have the right to stay on. They've done good work, and their attitude is, I'll continue to do good work as long as I can, and I don't know who's gonna follow me. You know, whether they'll be able to, you know, the person who follows me may undercut everything that I've tried to do. So I don't like that idea.
Okay, that's you're probably not on Twitter very much, Leon, watching people dunk on Justice Breyer for his recent remarks on this. Let me just open the door to, we are at the time we were going to end at 1 o'clock, but I did want to run a little bit long. If anyone did want to have a question, they wanted, rather than put it in the chat, they wanted to just directly ask Professor Friedman. You can raise your hand or do the old-fashioned, or you could put a question in the chat if you want to. This is a rare opportunity to ask Professor Friedman some of these questions. Not seeing anything right now. So yeah, that's okay. Oh, actually, let me bring in Mr. Fusco. Mr. Fusco, go ahead. You can unmute yourself.
There we go. Can you hear me?
Yep.
Okay. So my question relates to libel speech and the current state of our news media. Despite where someone falls on the political spectrum, everyone can agree that there's a problem with news organizations today having like a reckless disregard of the actual truth and only seem to be pushing undoubtedly their own narrative, regardless of how unverifiable their sources are. This can be seen undoubtedly with the Rolling Stone article that describes how ivermectin overdoses have caused Oklahoma hospitals to become overflowed, which was factually untrue and just unverifiable. But despite this was picked up by one news outlet after another without anyone seeming to care about the being able to verify the source. So with all that said, do you believe that the Supreme Court should revisit this issue and place a greater responsibility on news organizations to verify their sources before publishing an article, compared to the strict standard that we currently have that practically let these news outlets essentially say whatever they want with no risk of repercussions?
Well, all I can tell you is that, New York Times against Sullivan, Justice Thomas, just the other day, he says we should overrule New York Times against Sullivan. So what was New York Times against Sullivan? Some southern attorney general or police chief was going to put the New York Times out of business because they said something bad about the way in which things had operated there. I mean, is that what we want? We want really bad people to be able to lie and sue newspapers and put them out of business with outrageous cases? I mean, in other words, it's not the liberals, if I can put it that way, who lie most of the time.
Well,
I'm sorry.
well,
I'm sorry.
it's a matter of opinion, I think. But
Matter of opinion. I mean, New York Times against Sullivan, very important case. It really has to stay here. I mean, the answer to bad speech is more speech. Holmes said that, and it's still true today. I'm against, New York Times against Sullivan has to stay.
so you're not sympathetic to the argument that the nature of the media has changed, and the speed with which this stuff gets out, and people who are, who's a private person and not a private person is so different in a social media world that we need to impose greater obligations on those spreading information. Because to put it another way, misinformation, disinformation, is spreading, and liberals were complaining about it because it seemed to help Trump. So are you sure you're not more sympathetic to maybe some more restrictions on speech these days?
Absolutely not. Absolutely. The answer to bad speech that you don't like is more speech. Then you tell what really happened. And, presumably society will recognize, who's really right when all this comes out. You get a very bad Instagram, you write your own Instagram, instantly. And hopefully, society will work out who's really correct.
This is spoken like a classic ACLU lawyer. But that's fair enough. Fair enough. This is a hot issue, and I think the court is, like you said, Justice Thomas and other justices suggest they might want to revisit this one day, which is something new, right? That's it's a new shift. All right. So before we break, let me just go ahead and give you the floor for any last comments you want to make, Professor Friedman, about the court and the future that you think is going to happen in the near and short term, and then we'll close up.
Well, no, I think the court has done the job it's supposed to do. After 1953, before that, I'm not going to praise it, but I think it really has, looked at what the different pressures, the different movements in our society. There's recognized them. The whole idea of recognizing gay and trans people as human beings who have to have the same rights as other people, I think that was very important. I mean, just 2 years ago, that they did that. So I think the court is doing what it's supposed to do, which is to recognize society does change. Our attitudes do change. Our way of looking at life changes. And the law just has to, recognize that and not insist on staying, on the old way of looking at running society.
Well, thank you again, Professor Friedman. I would have some thoughts on this question, but I'll give you the last word to you on this one. But yeah, I want to thank everyone. We've gone over our time, so I want to let people go. But thank you again, Professor Friedman, and all of you for joining us. For this great, opportunity to talk about the Supreme Court and where we are on this Constitution Day. So thanks to you, and thanks to everyone who joined us on this Friday. I appreciate it.
Thank you.
All right, thanks everyone.
Leave.
Well, I'll leave it. Okay, take care.